Welcome to the Procurement Ethics and Compliance Workshop. Procurement ethics and compliance are governed by Hawaii Revised Statutes 103D, 101, and 106, and Hawaii Administrative Rules, Chapter 3-131. Procurement delegation authority comes with certain responsibilities. We will cover these responsibilities and the consequences if you fail to conduct or participate in procurement ethically and in compliance with the Hawaii Public Procurement Code. The Code of Ethics applies to any person, including any actual or prospective bidder, offerer, contractor, or business entity. This means it also applies to you as a state or county government employee. We often hear the word ethics, but what is ethics? Ethics is defined as rules of behavior based on ideas about what is morally good and bad. Ethics is knowing the difference between what you have the right to do and what is right to do. Specifically, purchasing ethics is a breach of public trust for personal gain, which is contrary to the Procurement Code. Sometimes the rules are silent, and we must use our common sense when conducting public procurement. Through workshops like these, the State Procurement Office tries to ensure that employees and vendors understand the Hawaii Public Procurement Code and are given opportunities to attend training workshops. Employees are encouraged to seek guidance about any situation prior to conducting the procurement. The SPO staff is available to assist you by phone, email, or if necessary in meetings. When conducting any procurement, all statutes and rules must be followed. Once informed of a problem, staff must take immediate corrective action to remedy the situation that is found to be contrary to the Hawaii Public Procurement Code to prevent it from reaching the level of a procurement violation. If an inappropriate action is committed, not correctable, and determined to be contrary to the Procurement Code, employees shall submit the SPO Form 16, Report of Procurement Violation, to the CPO as soon as possible. Ethics in procurement was formalized by the 2010 legislative session, which was passed and enacted into law. Act 207, effective July 6, 2010, amended the Hawaii Revised Statute, Section 103D, 101. It requires officers and employees of the state and counties who are responsible for conducting public procurement do so in an ethical manner. It also requires that any person, including any actual or prospective bidder, offerer, contractor, or business taking part in public procurement, to act in good faith to practice purchasing ethics and display business integrity. Hawaii Administrative Rule 3-131 on compliance currently provides parallel provisions for a procurement code of ethics for procurement personnel and private sector entities doing business with the government. Specifically, HRS 103D 101A requires public employees to act as a fiduciary and trustee of public or the taxpayers' money. They must remain independent from any actual or prospective bidder, offerer, contractor, or business, act only in the public interest, and abide by the statutes and administrative rules relating to public procurement. They must identify and maximize efficiency in the public procurement process. Also encourage economic competition by ensuring that all persons are afforded an equal opportunity to compete in a fair and open environment, and researching innovative goods and services to meet the public needs. Also, they must avoid the intent and appearances of unethical behavior. They must avoid social interactions with any actual prospective bidder, offerer, contractor, or business, or any other interested parties during the procurement process. They must maintain confidentiality in a manner that ensures a fair procurement process. Maintain impartial in dealings with any actual or prospective bidder, offerer, contractor, or business, or any other interested party. And finally, public employees must identify and eliminate any conflicts of interest. In addition to the statute, the Hawaii Administrative Rules 3-131-1.02 also requires employees who engage in procurement to diligently follow the procurement laws, rules, and procedures, and avoid soliciting or accepting money, loans, credits, discount, favors, or services from present or potential suppliers which may influence or appear to influence purchasing decisions. Ethical behavior is not only a requirement for public employees, but also any entity doing business with the state. All actual or prospective bidder, offers, contractors, or business entities taking part in the conduct of a public procurement shall act in good faith to practice purchasing ethics and display business integrity as a responsible offerer. Additionally, they must avoid the intent or appearance of unethical behavior. They must refrain from any activity that would create the appearance of impropriety or conflicts of personal interest and the interest of the state or counties. Identify and eliminate any conflicts of interest, and ensure that all persons are afforded an equal opportunity to compete in a fair and open environment. The bottom line, all parties involved in the negotiation, performance, or administration of state contracts shall act in good faith. In public purchasing, everything we do is transparent. We must ensure that all decision-making processes are of the highest ethical standards. We not only need to know our rules, but we need to follow them. If the rules do not achieve the highest ethical outcomes, they need to be changed. Ethical expectations pervade every area of our professional and personal lives. The Hawaii Revised Statutes and Hawaii Administrative Rules provide clear direction on ethical behavior. However, it is those gray areas that are most challenging. In a 2009 article in GoPro, the official publication of the National Institute of Government Purchasing, outlined 9 misconceptions to the ethical dilemma in public procurement. Of the 9, 4 are the most profound. 1. No one is watching. In this example, an accounting clerk failed her character test. She was responsible for canceling city-owned credit cards for former employees. Because of staff cutbacks, a review of credit card cancellations by another staff member was eliminated. Investigators later found several cards were not canceled, but retained by the accounting clerk. A bank employee questioned the use of the city's credit card to pay a utility bill on a private residence. Auditors later discovered over $100,000 in unauthorized use. The employee ultimately served more than 3 years in jail. Number 2, if I didn't know it was wrong, it must be okay. For example, a purchasing agency has a mandatory use statewide contract for certain goods. A new employee negotiated a contract with a vendor near her office for the same goods. After several discussions why the employee's actions were in violation of the existing mandatory contract, the new contract was terminated. While the supplier of the new contract realized the person who negotiated the contract did not have the authority for such action, they reluctantly canceled the contract. Ignorance is no excuse. Number 3, as long as I'm not receiving personal gain, it must be okay. In this example, at the request of the director, an employee ordered 11 vehicles instead of the 10 needed to replenish the agency's fleet. The 11th vehicle would be for the director's personal use, and the director wrote out a check when the vehicle was delivered. One employee did not think the transaction was right and reported the incident to the Ethics Commission. An investigation was conducted, and the judge stated, but for your position as an employee of the government agency, you would not have had the opportunity to make that purchase. Therefore, you violated the ethics rule. The bottom line, employees of a government entity should not use their position for any type of personal gain, regardless if it's for yourself or another employee. Finally, the end justifies the means, or if it saves the agency money, it must be okay. Occasionally, people who have contracting authority don't see the harm of steering contracts to family or friends. This is an unethical practice. For example, one contracting manager steered more than $85,000 over a 2-year period to a company owned by his son. Many of the contracts were under $5,000, requiring company petition. An investigation revealed the pattern of routing contracts just under $5,000 to his son's company. The manager was quoted as saying, "The work was performed satisfactorily, and I believe the city received a good product for a fair price, and I did not receive any personal gain from the work." Parceling or any other practice which inhibits or eliminates competition is unethical. Employees and business entities need not only be ethical in procurement proceedings, but they also must be in compliance with the Hawaii Public Procurement Code, which is governed by Hawaii Administrative Rules 3-131. Parceling is one of the most common procurement challenges. What is parceling? Parceling is the art of first, the higher the price of a group of procurements, the more likely they should be consolidated. 2, the more similar the good, service, or construction, or the more likely it is to be purchased a group of goods, service, or construction from one type of vendor, the more likely it is to be consolidated. For example, tree trimming, refuse, or disposal services on the same island. Or 3, the more foreseeable the procurement of similar goods, services, and construction, the more likely it should be consolidated. Whenever possible, a purchasing agency shall consolidate to allow for competition, for example, invitation for bid or request for proposal, particularly when the consolidated estimate expenditure for any 12-month period exceeds the small purchase threshold. The procurement officer is responsible for decisions to proceed with small purchase procurements rather than with the competitive sealed process. Let's take a look at a couple of examples. In case 1, an employee conducts a 7 to 10 small purchase procurements each fiscal year for plumbing supplies and repair services for the past 2 years. In a 12-month period, the agency purchases plumbing supplies and repair services from various vendors totaling $110,000, assuming you're not using the SPO price or vendor list. There are 3 issues identified in this scenario. 1, based on prior procurement history, plumbing supplies and repair services are foreseeable procurements. 2, activities are available from one type of vendor. And 3, executive branch departments are required to use electronic procurements for goods, services, and construction for procurements 15 to less than $100,000. What should you do? The agency should review the history of regular maintenance and services, which would include a list of the most commonly purchased items to determine if a formal method of procurement is necessary, for example, competitive sealed bidding or request for proposal. If a competitive process is warranted, the solicitation would result in an indefinite quantities or an as-needed type of contract where the exact number of supply or services are unknown. The contract does not have to include every item, but those most commonly used. In these types of contracts, there is no commitment to purchase any of the items listed. In case number 2, the current janitorial services contract will expire in 3 weeks, and there are no options to extend. You plan to issue purchase orders for the next few months until a new contract can be executed. What should you do? If janitorial services are needed without interruption, the agency may ask for a contract extension. Pursuant to Hawaii Administrative Rules 3-122-3, if a contract has exhausted its provisions for extension, or if the contract does not include a provision for extension, the agency may request, using SPO Form 3, an extension for up to 180 days. The form must be submitted and approved by the CBO prior to the expiration of the contract. Otherwise, the agency would have to cease the janitorial contract upon our expiration date until a new contract is in place. Any purchases made after the contract has expired is considered a procurement violation. The head of the purchasing agency is responsible for the agency's compliance with the law. Failure to adhere to the procurement rules and procedures will result in a procurement violation. Violations are normally inadvertent and the result of an administrative error, lack of knowledge, or simple carelessness, which may be avoided through the implementation of better procedures, employee training, and progressive discipline. Documentation is important in reviewing and making determination where improvements in the procurement process can be made by individual departments or agencies. Any improvements can be achieved best through the agency's own initiative. In the event of a procurement violation and request for payment, an SPO Form 16 shall be completed, reviewed, and signed by the head of the purchasing agency. If a procurement violation requires after-the-fact payment to the vendor, the SPO Form 16 must be approved and signed by both the Chief Procurement Officer and the Chief Financial Officer, and for the executive branch, that would be the Comptroller. Procurement violations may result in civil or criminal penalties. A civil penalty occurs when a person contracts for or purchases goods, services, or construction and knows that the procurement is contrary to the requirements of the procurement law In this situation, the person may be liable for all costs and damages to the state arising out of that violation. Violations that are the result of administrative errors or mistakes, ignorance or carelessness, are not usually subject to civil penalties. The determining factor is what the person understood the procurement requirements to be when the violation occurred, and whether or not the person believed he or she was acting in compliance with those requirements. A person who contracts for goods, services, or construction in a manner that the person knows to be contrary to the requirements of the procurement law is liable for all costs and damages to the state arising out of that violation. Additionally, the person may be assessed administrative fees. In order for criminal penalties to apply, a person must have knowingly or intentionally engaged in a scheme to avoid the requirements of the law. The violation must have been committed in a deliberate manner involving some calculated means, such as parceling for a single procurement, a deliberate misstatement of fact, or an after-the-fact purchase, which is purposely designed to avoid the requirements of the law. To undertake criminal prosecution, there must be legally admissible documentary evidence of the wrongdoing, which are available to law enforcement and authorities. Law enforcement authorities will also need to determine whether personal gain was intended or involved for either the person committing the violation, a friend or relative of the person, or the vendor, or whether some other vendors were significantly injured, whether intended or not. A person who intentionally or knowingly contracts for goods, services, or construction under a scheme of deceit to avoid the requirements of the procurement law shall be guilty of a misdemeanor and any applicable criminal penalties. Additionally, the person may be subject to removal from office and liable to the state or county for any sum paid in connection with the violation, and that sum, together with interest and costs. The state or county may also impose administrative fees. The AG will determine whether or not to pursue civil or criminal charges. In order for civil penalties to apply, a person must have knowingly violated the requirements of the law. In other words, the person committing the violation must be aware that he or she is acting contrary to the requirements of the law at the time the violation was committed. In addition to any civil or criminal penalties allowed by law, the Chief Procurement Officer may take action against any government employee found to be in violation. The action may include reimbursement for any sum paid in connection with the violation, including interest and costs, a recommendation for termination of employment, reduction or rescission of delegated procurement authority, and administrative fine. The Chief Procurement Officer may render a written decision on any person found in violation of any provision of this chapter and impose any of the following. If a person or actual prospective offer payment for sum in connection with the violation, including interest and costs, suspension or debarment action pursuant to statute, and administrative fines. Prior to imposition of an administrative fine, the CPO shall notify the person in writing that the CPO intends to assess an administrative fine. The CPO may assess an administrative fine in the amount of $5,000 for each violation involving a procurement, which amount is in excess of the dollar levels specified as small purchase. A Chief Procurement Officer may assess administrative fines in an amount not to exceed $1,000 for each violation involving a procurement which is less than the dollar level specified as small purchase. The person shall be given opportunity to be heard by the CPO. A request for a meeting shall be made within 7 calendar days after the receipt of the CPO letter. After the meeting, if any, should the CPO determine that the imposition of an administrative fine is appropriate, the person may request the review of the assessment through an administrative review of the CPO's decision pursuant to Section 103D 709 with the DCCA. In addition to administrative fines to the employee, the 2008 legislature passed Act 203, which allows the administrator of the State Procurement Office to impose an administrative fine on a procurement officer or another chief procurement officer who fails to take corrective action to remedy the situation or prevent its recurrence. Action may include training or reduction of an employee's purchasing authority. The administrative fines would apply if the procurement officer or chief procurement officer fails to take corrective action within 30 days from the date of notification for each day of the non-compliance. The fines may be assessed every day of the non-compliance. The Form SPO 16 is used to report a procurement violation and request after-the-fact payment. The form must include 1. The description of the goods, service, or construction procured, the applicable method of procurement used, for example, RFP, IFB, small purchase, sole source, emergency, exemption, professional services, or the SPO price or vendor list. 3. The facts and circumstances that led to the procurement and why appropriate procedures were not followed. For example, unanticipated, unplanned, lack of planning. Comments in this section must also address the questions: were there any indications of intent to deliberately evade appropriate purchasing procedures? For example, parceling, use of the P-card or purchase orders? Was there a lack of procurement information or training that contributed to the violation? For example, the person did not attend mandatory training, or there were no written procedures, or was this an inadvertent mistake? Also, was this a first-time occurrence? And finally, the corrective action that has or will be taken to prevent recurrence. SPO wants to know what appropriate written assurances and safeguards have been established to preclude a subsequent violation. For example, meetings, attendance at mandatory training, procurement authority rescission, posting of written procedures, etc.